that makes me think that there's probably more to the story, and there is, thankfully. We are the Armed Attorneys. Today we're talking about two critical cases that the United States Supreme Court declined to review and how this could impact gun rights going forward. Now, you're going to want to stick around because this isn't the whole story. But before we begin, show your support for the Second Amendment by hitting that like button. And today we're talking about two cases where the United States Supreme Court denied certiorari. This is the Aposhian v. Garland case and Gun Owners of America v. Garland. Now, these were both bump stock cases, and the Supreme Court of the United States started a brand new term October the 3rd, 2022, and these cases got chopped off basically immediately. And these are two bump stock cases, and they kind of have some big implications. So tell us about that.
Well, this goes back to 2017. We had the shooter at Mandalay Bay in Las Vegas, and there was an allegation, although I never really saw this substantiated by solid fact, I don't know, but there was an allegation that that person used a bump stock when he committed his mass shooting. And so there were calls everywhere, including from the NRA and from the Trump administration, to ban bump stocks. Rather than Congress actually passing a law, what happened was the ATF went in and essentially amended the definition of machine gun to include bump stocks. And I'm just going to give you the new definition that's in the CFR. And this is its new definition of machine gun. Machine gun includes a bump stock type device, i.e. a device that allows a semi-automatic firearm to shoot more than one shot with a single pull of the trigger by harnessing the recoil energy of the semi-automatic firearm to which it is affixed, so that the trigger resets and continues firing without additional physical manipulation of the trigger by the shooter. So the ATF went in and said, actually, bump stocks are machine guns. But this is problematic because that is not the statutory definition of machine gun.
No, and this is one of those rare instances where we see the Code of Federal Regulations not align with the United States Code. Generally, they follow the definitions that Congress provides them when defining rifles, shotguns, short-barreled rifles, short-barrel shotguns, and then we see this kind of misalignment, and it created this conflict of, hey, we have our elected representatives through the Congress defining a term, passing a law, defining a term signed by the president, and then we have some unelected bureaucrats coming in behind them and saying, we actually think this should be the definition that should control. And so you would think between those two bodies, which one would have, legitimate authority over this space? Well, clearly Congress, but the United States Supreme Court said, well, we're actually not going to resolve that dispute. And they were looking at a conflict under what's called Chevron Deference. And what's Chevron Deference?
It comes from a case out of 1984 that was Chevron versus the Natural Resources Defense Council. And essentially what Chevron Deference says is that courts must defer to a federal agency's interpretation of regulation or statute. However, there are steps to get to Chevron Deference. And I don't think it's worth going into here because it's really delving into regulatory state issues.
Yeah.
But, generally speaking, I think we can say, I don't think that bump stocks get us to Chevron deference, first of all. But, because we're not really reinterpreting, we're not interpreting a statute, we're not interpreting a regulation. What the ATF is doing is legislating. They're redefining machine gun. And that should be well beyond what they are capable of doing. And frankly, I'm shocked that the Supreme Court would deny cert on these two cases because it just seems so impermissible, number one. Number two, Neil Gorsuch, one of the reasons he wound up on Trump's short list for Supreme Court nomination is that he's really against Chevron deference, right?
Yeah, this is one of his kind of areas of expertise.
Yeah, so what are we doing?
Yeah, and I would say it's a shock to me as well because, and we've spoken with Clark Aposhian about his case, and he's a really good guy, and we were so surprised at the time. When we spoke to him, his case had been rescheduled for conference so many times, and after we spoke to him, it was rescheduled several more times. And usually that means that there is a judge that has some particular interest in the case, because it only takes one justice to reset this case for conference or to continue it, because they maybe want some other opinion to come out first before they try to render a decision on that pending case. And so this case was rescheduled so many times. And then to see the court on the first day of the new term say, hey, we're no longer we're not granting certiorari on these cases, is a little surprising. And there was no dissent from any of the justices. We see that from time to time that certiorari will be denied. And, one of the justices will kind of tip tip off, the states saying, hey, this is how you maybe should approach this when you come back and visit us. And so to see that there was a tremendous interest in the case and then denied without any kind of tip off from the justices, that makes me think that there's probably more to the story. And there is, thankfully.
There is. We have another bump stock case pending. It's pending in the Fifth Circuit. Actually comes out of the great state of Texas, and actually from a gentleman named Michael Cargill.
Yeah, I got my license to carry from Michael Cargill.
You did. Michael
Yes.
Cargill is a great gun advocate out of Austin, files lots of great lawsuits, actually. And so we have another bump stock case. It was heard by the Fifth Circuit, and the Fifth Circuit actually upheld the regulations as constitutional. But then what happened?
So we had a panel, a very small panel out of the Fifth Circuit. They vacated the lower court's decision, but then it didn't stop there. The court, the Fifth Circuit, decided, hey, we're going to review this case. We're vacating our panel's decision. We're going to review this case again. And what does that tell you?
Yeah, so the fact that they're going to take it en banc and that they're going to, it tells me that perhaps
Their panel got it wrong.
Yeah, that perhaps the panel got it wrong. I mean, there is, I think, a decent chance that the Fifth Circuit en banc decides that the ATF can't do this, that they have, in fact, made law, not interpreted law, in order to regulate. And so it will be fascinating to watch. Should that happen, it certainly will be appealed to the Supreme Court. Will the Supreme Court take it up at that point? I've got to think that this is something that is important enough for the Supreme Court. I mean, come on, guys. This is allowing federal agencies to just snatch things out of our hands. And it started with bump stocks. We know what's happening right now. It's going to keep going until someone tells them no. Tell them no, Supreme Court.
Right. And we had this discussion with Clerk Aposhian back when, and I think part of this may be there are wider reaching implications than just the gun community, because this affects the entire regulatory state as a whole. And so maybe it's just too seismic, or maybe that just wasn't the perfect case to implement the rule. I guess we will see, but we're excited to see. I'm optimistic about the case in the Fifth Circuit. I think that is a signal when they say, hey, our panel got it wrong and we're going to revisit this thing. I know Emily's a little bit more pessimistic about it, but we will have to wait and see. But that is not the end of the story when it comes to how these things get regulated. And, we have different levels or striations of, what rules or laws control. And I think we got some additional material that would be really helpful on that.
Yeah, if you are curious about why the ATF gets to control your life in the way that they can, I bet that you are. I think we have a good, common sense, spoken in plain English video that you'll enjoy. Take a look here. And until next time, we're the Armed Attorneys.